Facts. This case involves a 67,635 square meter of unregistered land in Benguet owned by Modesto Willy. Lorenzo Willy is Modesto's son. Modesto executed a written agreement in March 1963 conveying portions of the subject property to three persons who rendered services to Modesto. A. 10,000 square meters to Perfecto Hularbal, in consideration of his services as the surveyor. B. 27,365 square meters to Katbagen in consideration of his services as a lawyer. And C. 10,000 square meters to Dongpaen in consideration of his services as an agent. The property was surveyed in November 1968 for the benefit of Ricardo, a prospective buyer, to whom Dongpaen offered for sale his portion of the property. It was attended by Modesto, Dongpaen, and another surveyor. During the survey, a total area of 15,000 square meters was segregated for Ricardo's intended purchase. This portion was designated as lots 1 and 2. Subsequently, several sale transactions occurred among Modesto, Dongpaen, and Ricardo for the sale of lots 1 and 2 to Ricardo. On January 7, 1969, Dongpaen sold to Ricardo the 10,000 square meters portion of the property initially conveyed to Dongpaen by Modesto under the 1963 agreement. On June 17, 1969, Dongpaen sold to Ricardo an additional 5,000 square meters of the property. And on June 24, 1969, Modesto sold to Dongpaen an additional 5,000 square meters of the property ostensibly covered by a deed of sale notarized the next day. Later, it was agreed that Lorenzo would cultivate lots 1 and 2 for Ricardo on the latter's behalf, and that Ricardo's share of the fruits would be remitted to him. Modesto died in 1979. Later, upon learning that Modesto's heirs, herein petitioners, attempted to sell the subject property, including his portion, Ricardo started resorting to administrative remedies to protect his ownership over lots 1 and 2. Ricardo filed a complaint for partition of property and damages against the heirs of Modesto before the MCTC, claiming ownership over lots 1 and 2. The issue in this case is whether the MCTC has jurisdiction over Ricardo's original action for partition of property and damages. Ruling, yes. In this case, the primary relief sought by Ricardo is the recovery of purchased property, which had long been identified, separated, and segregated from a larger parcel of property, the herein subject property. The allegations in Ricardo's complaint likewise included his claim of possession, in the concept of owner, of lots 1 and 2, through Modesto's son, Lorenzo, who was purportedly only cultivating the lots on Ricardo's behalf. Moreover, Ricardo alleged that Lorenzo regularly delivered to him the fruits of lots 1 and 2. These averments of possession in the concept of owner and receipt of fruits were made to support Ricardo's claim of ownership of lots 1 and 2, and the consequent reconveyance thereof to him. Suffice to state that, palpably, Ricardo's complaint involves title to real property. In this case, Ricardo instituted this complaint hinged on his cause of action that Modesto's successors in interest, specifically Lorenzo, actually claimed ownership of the entirety of the subject property, repudiated Ricardo's ownership of lots 1 and 2, and offered the whole subject property for sale under the same claim of ownership. Clearly, since the alleged assessed value of lots 1 and 2 is 19,100 pesos, the MCTC properly exercised jurisdiction over Ricardo's complaint.